The next case to come before the court is the City of Akron v. Homell T. Calhoun. Are both parties present? Good morning. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for a rebuttal. If you do plan to reserve time, please let me know so I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium, keep your voices up, introduce yourselves. You should not use the names of children, minors, and victims during your argument. You can refer to those folks should it be relevant by their initials or terms like the child. The judges have read both of your briefs and we are ready to proceed when you are. And I would just ask you, Mr. Calhoun, would you like to reserve any time for rebuttal? You can reserve up to 5 minutes.
If I have some time left, I would like to reserve it. I don't think I'm having much time left.
Okay. Well, I will just put you down for 5 minutes and let you know when you're at 5 minutes, okay? For rebuttal.
I've got a lot.
Okay. All right. Well, why don't you go ahead, step up to the podium and proceed.
Good morning, judges. May it please the court. My name is Homell T. Calhoun, and I'm a pro se appellant in this case. I would like to reserve any remaining time for a rebuttal. I'm going to address this court on just 3 assignments of error today. Those assignments of error are numbers 1, 2, and 4. I'm going to rest on my brief regarding errors number 3, 5, and 6. Let's start with assignment of error number 1. I was convicted of a 4th-degree misdemeanor disorderly conduct by intoxication charge. However, normally this disorderly conduct charge is only a minor misdemeanor under Akron Ordinance 132.01B2. Unless the trier of fact in this case, the jury should find that the aggravating element that I persist in disorderly conduct after reasonable warning or request to desist as stated under Akron Ordinance 132.01E, or unless the jury verdict form should state that the offense is a 4th-degree misdemeanor. As you have already seen in the record, the jury verdict form in my case did not have either one on it. Under Revised Code 2945.75A2, this means that I can only be found guilty of the least possible degree of the offense under this ordinance. In this case, that would mean that the jury only found me guilty of a minor misdemeanor. The Ohio Supreme Court has stated in State v. Pelfrey that it does not matter whether the jury instructions addressed the aggravating element, nor does it matter that there was evidence of such an aggravating element presented at trial. The outcome is that the conviction drops to the least possible degree of the offense under the statute. In State v. Taylor, the 11th District found a jury verdict form to be deficient to convict Taylor of a 5th-degree felony marijuana trafficking charge and ordered the trial court to enter a judgment of conviction to marijuana trafficking, a minor misdemeanor. Now, the city has stated in its brief that I never argued this in the trial court. Therefore, a plain error standard should apply here on appeal. However, the city is wrong on its facts, as I did argue this issue in the trial court in my timely filed Criminal Rule 29C motion for judgment of acquittal, docketed with the trial court on September 20th, 2022. And the city actually responded to this motion in a timely manner on October 14th, 2022. So this is not the first instance of arguing this issue. Moreover, as this court found in State v. Wells, a Pelfrey issue can be raised for the first time on appeal by the defendant, since it's the city's responsibility to call to attention errors that prejudice it. Now moving on to assignment of error number 2. At trial, the burden was on the city to present sufficient evidence in a light most favorable to it to provide each and every element of the offense of disorderly conduct by intoxication beyond a reasonable doubt. Akron Ordinance 132.01B2 states in pertinent part, No person while voluntarily intoxicated shall engage in conduct or create a condition which present a risk of physical harm to himself or another, or the property of another. The key element at issue here is whether the city presented sufficient evidence to prove that I created a condition which presented a risk of physical harm to me, and the city argued at trial and during my criminal rule 29A motion for judgment of acquittal. As stated by the second district in State versus Silkowskis, the second element requires some affirmative showing of dangerousness as the sole fact that I may have been intoxicated at the time I was asleep in the grass on Akron Children's Hospital property does not give rise to a violation of disorderly conduct by intoxication. The evidence at trial was clear from Officer Dorsey's mouth. He put me on the grass of Akron Children's Hospital property opposite of the Devil Strip. That means I was on private hospital property. That evidence shows that I was nowhere near the street where a passing car could have run me over. The only way that a passing car could have possibly run me over is if it had been driving over the curb, through the Devil Strip, past the sidewalk, and well onto the grass of Akron Children's Hospital property. My taking a nap at this time was the safest act available to me, as I needed to rest up a little bit since I was at least 30 minutes from walking home at this time. I was not passed out drunk. The evidence at trial bore this out through Officer Dorsey's testimony. As all three officers testified to, I was alert within 30 seconds of attempts to wake me up by Sergeant Lindsay, and I was calm, coherent, steady on my feet. As Officer Dorsey testified to, I was in full possession of my faculties upon being awoken. The only issue that arose was that as the officers were talking to me, I kept putting my hands in my pockets, and they told me to stop doing that. Then they grabbed my arms and tried to force my hands out of my pockets. This is when I began to resist, fall down, and become verbally belligerent with the officers. None of that conduct was caused by me being drunk. It was caused by the officers trying to rip my hands out of my pockets. In State versus Parks, the second district found that when an intoxicated defendant ignores a request by a police officer in public and is then physically assisted into complying with the request by the officer, no violation of disorderly conduct statute occurs just because the intoxicated defendant could have been injured when the officer forcefully made the defendant comply with his order. The officers further testified that they arrested me for disorderly conduct because they did not think it was safe for me to walk home based on my alleged level of intoxication. However, in Silkowskis, the second district found that simply walking home while voluntarily intoxicated was insufficient evidence to convict someone of disorderly conduct by intoxication. So in this case, on appeal here today, we have my sleeping in the grass on private hospital property while allegedly intoxicated. That is not affirmative. That is not an affirmative showing of dangerousness on my part. And we have my not being allowed to walk home while allegedly intoxicated. That is also not an affirmative showing of dangerousness on my part. Now, I argue that in this case, I argue this case is more akin to the court's decision in Lorraine versus Wright and can easily be distinguished from this court's decision in State versus Davis, which the city cited in its brief. In Wright, the court found that the evidence was insufficient to convict an appellant who was drunk and asleep in his locked and operable car in his ex-wife's driveway, even though he was trespassing on his ex-wife's property and had, in fact, been thrown out of his ex-wife's house. In Davis, the court found that the evidence was insufficient to convict an appellant who was drunk in his unlocked, operable car parked illegally on public. In Davis, the court found that the evidence was sufficient to convict an appellant who was drunk in an unlocked, operable car parked illegally on a public street in front of a bar. The court then likened the situation in Davis to the drunk who curls up to sleep in a doorway in freezing weather, which is what the committee commends for disorderly conduct by intoxication. State is an example of sufficient evidence to prove the the charge under RC 291711B2. Now, in Davis, Wright, in my case, all three appellants were asleep. So the mere fact that one is asleep and intoxicated outside is not good enough to prove an affirmative showing of dangerousness on my part to convict me of disorderly conduct by intoxication. The city needs more. Clearly, Davis committed an affirmative act of dangerousness because he was passed out drunk in front of a bar and his car was both operable and unlocked and parked illegally on the street. In such a case, the mere fact that the car was operable was good enough to find Davis guilty on this charge, as the second district found in State versus Tillman. But there's even more affirmative showing of dangerousness than that in Davis. Davis was parked in front of a bar in an unlocked car. I think we all know that other drunks and riffraff are going to be at the bar late at night and could have therefore robbed Davis while he was asleep, or they could have attacked him and stolen his car. In my case, none of what was in Davis exists. I was walking home from the bar around 2:40 in the morning when I became too tired to finish my trek home. I found a comfortable place in the grass on Akron Children's Hospital property to lie down and to take a short nap before I finished the final 30 minutes of my walk home. In this area, there are no bars around. There is no evidence in the record there were any other people walking around about who could possibly harm me, which differs from the situation in Davis, when one is asleep in front of a bar late at night while drunk. Even Sergeant Lindsay drove by in her cruiser and saw me asleep in the grass. She and the other officers were not walking around. Also, as Officer Dorsey testified to, the area where I was asleep was away from the double strip and on the other side of the sidewalk. So no car could have driven by and run me over unless it had lost control, driven over the curb, past the sidewalk, and well onto Akron Children's Hospital property. For that to happen, it would either have to be intentional or a freak accident. These facts clearly fit better with the facts in the court's decision in Wright, more so than the decision in Davis. And the city's other argument, which is that I violated Akron Ordinance 132.01B2 because I was allegedly so drunk that after waking me up in the grass, they did not feel it was safe to let me walk home because I could have been hit by a car, also fails, as that is not an affirmative showing of dangerousness on my part, since I never got the chance to walk home in the first place. Now let's move on to the assignment of error number 4. Prior to trials, the city moved to amend the complaint from Akron Ordinance number 132.01A1 to 132.01B2. My lawyer objected to this amendment because he had prepared a defense for subsection A1, and amending it to B2 would change the element of the offense that he had prepared his defense for. This also violated Criminal Rule 7D, as it changed the identity of the crime charged. In State v. Ryan, the second district found that the trial court should not have allowed the state to amend the charge of domestic violence under RC 2919.25A to RC 2919.25C, since it changed the identity of the crime charge. As you can see, all it did was merely switch the charge from subsection A of the domestic violence statute to subsection C of the domestic violence statute. The second district also went on to say that Ryan did not have to prove that he had been prejudiced by the amendment, since Criminal Rule 7D flatly prohibits such an amendment. Your Honors, the city wants you to believe that this amendment was all right because it did not change the penalty or the degree of the offense. But the city's thought process is completely contrary to Criminal Rule 7D, which clearly states that the amendment cannot change the identity of the crime charged either. This has also been followed by the 5th District in State v. Wright, which found that amending a charge for a child enticement under RC 2905.05 to RC 2905.05C changed the elements and therefore the identity of the offense, as well as by the 11th District in State v. Pignoloso, which found the same thing when a charge of wrongful entrustment of a motor vehicle was amended at trial from RC 4511.203A4 to RC 4511.203A1 and 2. The only thing that the city can amend without dismissing the case and refiling the complaint is something like changing the date of the offense or the conduct of the offender. For instance, in State versus Hickman, this court found that amending a rape charge from fellatio to cunnilingus did not change the identity of the offense charged, since it just changed the conduct of the offender. It did not change the elements of the offense in any way. Also, as found under Picoloso, since I did not consent to the amendment, but actually objected to it, that means the amendment was improper. Now, assuming arguendo that you find that the evidence was sufficient to sustain a conviction under Akron Ordinance 132.01B2, but that a pelvic violation had occurred here, which acquits me of the fourth-degree misdemeanor for disorderly conduct, but not the minor misdemeanor offense, as well as a criminal rule 7D violation, since the city's amendment from Akron Ordinance 132.01A1 to 132.01B2 changed the identity of the crime charged. I would argue that double jeopardy applies here for any retrial of this matter under the fourth-degree misdemeanor disorderly conduct charge. If this court should only find that the assignments of errors number 1 and 4 should be sustained, then the court should remand the matter to trial court to retry the disorderly conduct charge under Akron Ordinance 132.01A1 and only for a minor misdemeanor charge.
Mr. Calhoun, I'm going to ask you to wrap up because you've used your time.
Which means that I would not get a jury trial again. Instead, I would get a bench trial before Judge Hamilton this time around. Thank you, Your Honors. I ask you to reverse my conviction for disorderly conduct here and remand the matter to trial court.
Thank you.
Good morning, Your Honors. Brian Bremer on behalf of the City of Akron. Ms. Smith was supposed to be here today, but she had another commitment that came up. So I'm here again, and at some point I will be here when something moves smoothly through Akron Municipal Court. Because this again is a case where there are a number of issues that are unusual that arose in this case. And I think starting with the actual amendment of the complaint is a good place to begin with. The reality is, Mr. Calhoun's counsel did object to the request of the prosecutor the day of trial to amend the complaint. Mr. Calhoun here at oral argument said that this was prejudicial because they had prepared a defense as to A1. Well, to the extent that's true, the remedy would have been to have a continuance, and that's not the argument that's being made on appeal. The issue here on appeal is whether this was an amendment was even permitted. And the Supreme Court has said that 7D allows an indictment or complaint to be amended to cure a defect, even if the original indictment omits an essential element of the offense. That goes beyond what Mr. Calhoun purports that 7D to require. And what happened here was the complaint that was in the file at the Akron Municipal Court, the document labeled complaint. That's an important distinction I'll point out, I'll get to in a second. Charge under A1. B2 under the Akron Code has a voluntary intoxication aspect to it. And so this did change that, it added that element, but that's an essential element that would be in line with what the Supreme Court talked about in Davis, we believe, versus it changing the identity of the actual charge, because it's still disorderly conduct, it's still an M4 or a minor misdemeanor. And the reason I said I wanted to point out what's labeled as a complaint is that under Criminal Rule 3, a complaint is a written statement of the essential facts constituting the offense charged. It shall also state the numerical designation of the applicable statute or ordinance, it shall be made upon oath by any person authorized by law to administer oaths. And the pertinent aspect of this is, the file also includes the field arrest summons form, which charges Mr. Calhoun with violating 132.01B2 of the Akron Code. That field arrest summons form is signed under oath. That would qualify it as a complaint in this case. And I point this out, and I recognize that this, to be clear, this was not an issue that was pointed out in our brief. I noticed this when I was preparing for this case. I'm bringing it up now so that this court can consider that, simply because this court can affirm for any reason what happened below. But I understand this is an argument that's not being raised, so I don't want to mislead the court on that point. But this is sworn under oath, and it does charge Mr. Calhoun with violating the code section that that the amendment was made to. So in the sense that there was not really a change to the complaint, this framing that happened both here and in the municipal court is not entirely accurate on the face of what's actually in the record. But that's, again, I'm pointing that out. This is something that I leave up to the court's discretion about how they want to handle that issue.
I hate to move you along, but you only have so many more minutes,
Yes.
and there's lots of issues here. I did want to talk about the verdict form issue.
Yes.
How do you counter that? There's no level of offense on the verdict form, there's no aggravating factors whatsoever. It's not something that has to be raised at the trial level, it just has to be on the verdict form.
Well, Your Honor, respectfully, we are relying on State versus Aford. The Supreme Court case says it does have to be raised. And the Supreme Court said if you don't object to the form or bring it up during sentencing, it is a plain error analysis.
Well, counsel, is Aford really what is controlling here? Aren't there some other Supreme Court cases out there? Pelfrey, for example, that has been discussed here in McDonald.
Well, yes, Your Honor. Pelfrey predates Aford. So first of all, the Aford
What about McDonald?
McDonald doesn't actually address whether or not there was an objection at the trial court. It's never been brought up.
Well, we just had a case here, State versus Darby, there was no objection.
I appreciate that, Your Honor. I can't distinguish this case from, say, this court's recent decision. Our position would be the Supreme Court's position should hold, and to the extent this court is going to distinguish that or follow McDonald, that's a position beyond what I can argue. Aford is what we base our argument on, and we would argue there was no argument of plain error. We would also argue it doesn't meet plain error. But to the extent that there is an issue with it being reviewed solely on what the form says, then we would agree that the form is not sufficient for an M4 on its face. But again, we made the argument for under Aford, however you want to say that name, we believe that one specifically called out a lack of objection at the trial court, whereas Pelfrey and McDonald did not say anything on that point. It is subsequent to Pelfrey, and it also it says specifically it's a plain error analysis. Mr. Calhoun didn't make a plain error analysis, and we point out that we think that the evidence would have been sufficient to actually convict him of the M4, so we wouldn't have been but for it was not clear that the outcome would have been different if the actual error had been raised. So that's what the city's position is. But obviously, I understand the fact that this court's recent decisions have come out different than what the argument that we made in the brief is.
I'm sorry to jump ahead of you,
Yeah.
but the jury instruction issue about the defendant's right to, that the defendant has the right to remain silent, and that's not supposed to be used for any reason, that the defendant's not testifying, that jury instruction. Did you find any case where that the judge didn't give either the instruction for the right to remain silent, or when the defendant does testify about the credibility issues involving the defendant, there's two counter instructions there depending on if the defendant testifies or not. Are there any cases where that instruction isn't given and is raised as an error?
I would have to answer, I do not know. I do not know if there's a case where the instruction was not requested here, and the Supreme Court case said when it's requested, you have to give it.
But isn't that a fundamental instruction, one or the other of those? more fundamental when the defendant doesn't testify?
I think that I guess I would say that I don't know that there's any, I'm unaware of any case that says that it has to be given when it's not requested. And I know that we made the argument in our brief. I apologize for saying it like this. I did not write this brief, so I'm filling in, and so I apologize. I cannot say what was and was not discovered. And I think that if that case had been found, I have every reason to believe that it would have been brought to the court's attention, because we do take the obligation to bring to attention of contravening or cases that do not help our case. We do take that seriously to bring that to the court's attention. And I would have every reason to believe that Ms. Smith would have included that in the brief if that had been known, been recognized, and had an attempt to try to correct it.
I think my question was directed towards that specific instance, because there's lots of case law about getting certain instructions in and what the onus is on the party asking for the instruction. But in this case, that one, my question is this one that needs to be even asked for in this circumstance? Or is it an onus on the court to make sure that that instruction gets in? Maybe there's no case law on that.
And again, Your Honor, I don't want to represent that there is not. I just don't, I do not, the short answer is I just do not know. I think that, again, if it wasn't requested, I think the analysis would be plain error. And again, you have to say that what would have come out a completely different way. I don't know if there's anything that in the record that would lead you to believe, that would lead someone to believe that if this jury instruction would have been given, the outcome of this trial would have changed. The testimony was, no one attacked Mr. Calhoun for not testifying. That didn't come up. Like, that wasn't something that was, no one was bringing that up. No one was accusing, making implications or accusations on that front. It was just.
What about in voir dire? There's often a question asked, who here thinks that the defendant doesn't testify that he's guilty or hiding something? Because they presume that instruction will be given, and it's so fundamental to know that you're not allowed to use the defendant's silence against him. Do you know if there's anything in the voir dire process where that was mentioned?
I do not know if that was a question that was asked in voir dire. I would say that I would be very surprised that would be a question asked by the prosecution.
Sure.
And to the extent that then occurred, that would be an invited error on behalf of the defense counsel to do that in this case. That would be our position at least. I'm happy to try to address any more questions on the questions, but I do think that quickly addressing, I do want to address, I guess, two things with the Pelfrey issue. The first is that, one thing with the Pelfrey issue. The first is that Mr. Calhoun argues that he did object at the trial court about the instruction when he put in his 29C motion. That motion occurred after the court had already imposed a sentence and journalized it. And the reason that matters is that means that it wasn't actually raised at with the instructions or at sentencing. And also 29C is not the proper method to actually go about trying to raise that.
Counsel, but
Yes.
does it really even matter if it was raised in light of Pelfrey and, I would say, Darby and Dunn?
I appreciate that, Your Honor. We rely on Eford. And then again, to the extent the court disagrees, then
Your argument is that it's not a strict compliance.
yes. Yes, Your Honor. And my point of bringing this up is only that 29C goes to sufficiency of the evidence. It's a motion for acquittal, and it allows you to reduce. It doesn't address the idea of the Pelfrey. Pelfrey is a different issue. Pelfrey is whether the jury found enough to convict you of a higher offense. 29C goes to whether is the evidence sufficient to get us there. And that's the issue that I'm saying, as far as it's the improper method to actually preserve it, to the extent it needs to be preserved. Yeah. And then as far as the sufficiency of the evidence, we laid out in our brief that the risk to the harm to others comes from not only, the risk of harm to persons comes from Mr. Calhoun's behavior after he was awoken at again, as Mr. Calhoun acknowledges, he was unconscious in the lawn of Akron Children's Hospital at 2:40 in the morning, and it took over 30 seconds. It took 30 seconds or more to get him conscious, and then he had slurred speech, bloodshot eyes, was unsteady on his feet, and when he was jostling with the officers, not just because the officers were trying to get his arms out, he was actively jostling with them, and that action, while keeping his hands in his pocket, our argument is that he is causing a risk of harm, because if he falls, he's not going to be able to catch himself, and or he could knock the officers over because of this interaction. That's where the actual harm would come in, and the officers told him to stop, and he continued doing it. That's why there's sufficient evidence in our mind for the M4. There's sufficient evidence, which requires that you continue after being told to stop. There's sufficient evidence for the MM, because it's just a sort of conduct causing the harm to others. Mr. Calhoun argued in his brief that this was not preserved by the city because it wasn't argued in response to a couple 29 motions during trial. Criminal 29 motions, just as a point of fact, while they weigh sufficiency, they are actually separate from a sufficiency analysis on appeal. And Mr. Calhoun has not argued that the court erred in denying his 29 motions. He's argued that there's insufficient evidence. And so even to the extent the city had to actually make specific arguments in response to a 29 motion in order to preserve them on appeal, that's not this is outside the scope of those 29 motions. He's arguing specifically about sufficiency of the evidence in total. And we were able to look at the entire record and make arguments based on the entire record. That's the assignment of error that he raised. So and his counter to us pointing at the entire record is that specific arguments made in response to Rule 29 motion don't make those same arguments. I don't think that would actually be binding on appeal regardless, but the point is this actual assignment of error here is not within the scope of what his counter argument to what we raised for sufficiency purposes. And if there's no further questions, the city would respectfully request that you affirm.
Thank you very much. Any questions? Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. On the day that it is released, the clerk of courts will mail a copy of the decision to you, and it will also be posted on the Ohio Supreme Court website. Thank you both again.